It's 2025 and a new year means brand new opportunities. And for a lot of you out there, I know you've been thinking about one thing over the holidays, and that is starting your own business. But you have so many questions like, how do I get started? How do I come up with a brand? How do I even sell stuff to people? And what am I even going to sell? Now take a deep breath. Shopify has got you. Shopify makes it simple to create your brand, open for business, and get your first sale. And you can get your store up and running easily with thousands of customizable templates. You don't have to be a coding nerd or a design geek to get this done. All you need to do is drag and drop. Shopify also helps with the details like shipping, taxes, and payments from one single dashboard, so you can focus on the important stuff, like growing your business. Established in 2025 has a nice ring to it, doesn't it? Sign up for your $1 per month trial period at shopify.com/truecrime, all lowercase. Go to shopify.com/truecrime to start selling with Shopify today. Shopify.com/truecrime.
I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined, as always, by my responsive co-host, Brett.
Hello, Alice. I'm always ready to respond to any of the allegations you make against me.
Well, that's really good, Brett, because today I've been waiting for this. We covered kind of the bombshell filing by Pooty Poop, the Murdaugh defense team, about a motion for a new trial alleging very serious allegations of jury tampering. And we always said, but wait until you hear the other side. And the state has filed their response, and there is a lot to discuss in what they respond to, the affidavit they attach, the reports and the investigation that they conducted into the allegations that's also attached to their response, and what this means for a potential evidentiary hearing and whether there's going to be one. So there's so much to talk about tonight, and Brett, I'm ready.
I'm ready too, and I am so excited to be talking about something other than Delphi on Legal Briefs, because it seems like that's all we talked about lately. You know, it's funny because we got sick of Murdaugh there at one point, but Murdaugh is like an oasis in a desert at this point. So, and one thing I want to say, those of you who've read these, if you haven't read these filings, read both of them. Read the defense's filing and read the prosecution. These are really good legal products. These are very well written. They contrast pretty sharply with what we've seen in Delphi. A lot of people have read a lot of the stuff in Delphi, and it's barely legal writing, the stuff that you see in Delphi. It's very sort of emotional. It's very sort of fact-based. It's not legal at all. Whereas these are really well done, and they're done the way you expect to see. So they do things like set out the law, and then they explain to you how the facts, in this case, fit the law and what should happen because of the law and because of the facts. And that's really the way it should be. You really should be able to read both of these. And number one, see some of the weaknesses in each argument. And I think you do. And I think both sides do a good job of pointing that out. But also, you should be able to read these as a layperson, frankly, and yourself kind of have a feeling about who has the better side of the argument. So I am looking forward to talking about it. As we said when we talked about the initial filing, these are serious issues. I think these were serious claims by the defense. This was not a frivolous claim. Those of you who watched the Charlie Adelson case, there was a filing after that case that asked the judge, accused the jurors of some misconduct and asked for an evidentiary hearing. And like a day later, the court denied it. That was not a serious claim. These claims are serious, and they required a serious response from the state, and you saw that in this filing.
Yeah, not only was it a serious response from the state, but as you can tell if you read this 25-page response with a lot of exhibits, they conducted an investigation because these are such serious allegations that they do warrant an investigation, because we talked about this before. There is potentially, criminal or at least conduct being alleged here. So here we have if those of you who have not read the Murdaugh filing for a motion for new trial, to kind of sum it up, the defense said that the clerk of the court, Rebecca Hill, had published a book in August, and that was kind of what set off their knowledge of information that could lead to allegations of jury tampering. In particular, they alleged that Ms. Hill pressured individual jurors into, not listening to or not giving weight to Murdaugh's testimony. Absolutely not allowed if she did that. And having one-off conversations with jurors, potentially talking about things she couldn't be talking about to do with the case or the evidence. And in addition to making these allegations, the defense actually attached affidavits to the motion. One was by a dismissed juror, and then there were a couple affidavits that reported what yet other jurors said to the defense team, but it was actually an affidavit by the paralegal on the defense team, not signed or sworn to by the jurors who allegedly said those things, among kind of some other things. So that's basically the background you need to know. But like Brett said, go read that filing because it does make some very serious allegations. We've talked about this. Jury tampering is very serious. And what the defense is asking for is an evidentiary hearing to kind of get to the bottom of this. Did this happen? And before they do that, whenever you have a motion, the other side has a right to respond, and that's what the state did here. They filed a response addressing a lot of the allegations, and they address the law. So we've talked about this all along. You can't just simply say that, there's been kind of wrong conduct. We've said that there has to be some sort of prejudice. This would have had to affect the outcome. And they lead with that. They kind of try to suss out what is important to respond to in this motion, because even as we pointed out in going through Murdaugh's filing, some of it's very serious, and then some of it's kind of for affect, right? We talked about how they throw in a lot of information about egg juror, right? The egg lady who was dismissed, and kind of all the different communications surrounding her dismissal. And we said that that actually wasn't kind of their key claim. It wasn't going to be their strongest argument that there was jury tampering so serious that they needed to have a new trial. And another thing that we talked about was that these affidavits, though it seemed very serious, especially kind of the affidavits signed by the jurors, that we're only getting one side. An affidavit's typically written by an attorney, and it is written in a very specific way where the person who's swearing to it can attest to every word that's written on that page, and there's kind of no cross-examination and no testing of those facts. And here we begin to see that there is another side to the story.
And I think if you read the prosecution or the state's response, you'll see they have probably three objectives. The first one is to narrow the scope of what's being discussed. So, as we talked about and as Alice just mentioned, there are things in the defense's filing that really are more for the press, frankly. I mean, there was more for the press conference. And you see that a lot of times in these legal filings in big cases, sometimes more than others. The egg lady stuff, the state does a really good job of explaining exactly why she was removed, explaining why sort of the kind of hazy allegations in the defense's filing about egg lady and her removal don't really make sense and just doesn't really fit. Like there are some serious allegations, and then there's those, and they're pretty weak, and they spend a pretty good chunk of the document really sort of laying that out, because I think they want to go ahead and address that and push that aside. I think the state knows they're going to get to an evidentiary hearing. There will be an evidentiary hearing, and they're trying to narrow the scope of what that evidentiary hearing will be. The second way they do that is they point out that a few things that are alleged by the defense are improper to even consider. In South Carolina, in most places, what happens in the jury room between the jurors is inviolate. You don't get to look at that. You don't get to review that. You don't get to consider it. So you may recall that in one of the jurors' affidavits, she said she voted guilty because she felt pressured by other jurors. Doesn't matter. Like, that's going to happen in deliberations. We're not going to put the jury on trial. We're not going to review that kind of stuff unless there's something truly egregious, like some real racial stuff or some sort of really discriminatory stuff, unless that's happening in the jury, we're not going to discuss it. So that stuff should be out. So the first thing, narrow down the scope of what we're talking about. The second thing was say, look, we don't even need an evidentiary hearing. Assume everything's true that you've read here. It doesn't meet the standard. Alice talked about prejudice. And one thing they say is, in order to show prejudice, you have to show that these comments might have affected the jury and might have affected how the jury weighed the evidence. And they say, look, even in the affidavits by the one juror that we have, so we've eliminated Egg Lady, she wasn't there for the deliberations. She never says these comments affected how I voted. So therefore, no prejudice. And they also say you shouldn't consider the affidavits of the paralegal because they're hearsay. Now, interesting thing about that, this is not a trial. We're not in a trial situation. So the hearsay rules apply in a much looser fashion. Basically, the defense has to establish a prima facie case that we need a hearing. They have to show there's a legitimate question here that if it's answered in a certain way would result in a benefit to us, in this case, a new trial, and we have some sort of conflict in the facts, right? So they're wanting that evidentiary hearing. The prosecution is trying to stop that from happening. But because of the lower standard, I don't know that the prosecution will succeed in saying you shouldn't even consider those other affidavits because that's hearsay. Now, I think the prosecution has to know they're probably going to fail in this argument that there shouldn't even be an evidentiary hearing. But I think it's smart to make it because you're sort of laying the groundwork for how high the bar is for the defense. You are sort of setting up, so you've narrowed the scope. You've argued we shouldn't even have one of these. And if we do have one, the bar is really high. The defense has barely even started to meet it. When we have this evidentiary hearing, by the way, it shouldn't be Pooty Poot getting to ask any questions of jurors. That's another thing they do a really good job of laying out. It's the judge. And that's important because you don't want these defense attorneys cross-examining jurors. So it'll be done by the judge, whether it's Judge Newman or somebody else. And I think it was just a really effective response by the prosecution. There's still open questions. I think there still needs to be a hearing, but I think the prosecution did a good job pushing back.
Yeah, absolutely. I agree with you that there should still be a hearing. We can get into kind of what parts kind of trigger that need for a hearing. But I think that's a great point, Brett. The affidavits attached to Murdaugh's motion were obviously all interviews conducted by the defense. And the state cites very effective case law and an on-point case law that says that this questioning should not be done by any of the parties. Why not? This makes sense intuitively, right? When you're talking to one side or the other, we tend to want to agree with people, and either side is an advocate for a particular side. And that's why that case law says that it's supposed to be the judge asking those questions. So even though those affidavits were not improper, except I would say, potentially the paralegals affidavits. But again, it's kind of underlining for everyone who's reading these filings, really the public as well as the court. Like, yes, there's these affidavits, but you can't take them at their word for many reasons, as we all know. For one, the law is very clear that you don't get to be questioned by the advocates on either side, because what you're trying to get to is not, I'm right because I'm the defense or I'm right because I'm the prosecution. This is wholly separate from the Murdaugh case with respect to like the murder charges brought, right? This is a separate case that is an offshoot of what happened during that trial. And that's why the judge needs to be asking those questions.
And I think there's a couple things, as we often say, the law is complicated. If it wasn't complicated, we wouldn't have a job, right? So particularly in this case, you have a few competing precedents that I think it will be interesting to see how those precedents are weighed by the court. The defense really focused on the best precedent for them, which was a case that basically said if court staff are involved in whatever the misconduct is, then it's almost you assume the prejudice, and if it happened, you reverse. You can imagine why they want that. Because, and as we'll talk about, it seems like Becky, she definitely had conversations with the jurors, and she may have said some things she shouldn't have said. And from the defense's perspective, they're trying to say, look, the standard is if that happened, new trial. The prosecution focuses much more on the precedents that talk about prejudice, like Alice was saying. Okay, so she may have talked to him. She may have talked to him about things in the trial, but you have to show prejudice. I think the law is probably on the prosecution's side, but you do have this sort of divide in South Carolina law where it seems like cases are saying two different things. We talked about this a little bit the first time we addressed it, but I think it's going to be really interesting to see how the judge and ultimately probably the South Carolina Supreme Court come out on what the actual standard is.
And that happens all the time, right? There are thousands, tens of thousands of cases, going through any court system. And sometimes you'll get a fact pattern. We always say bad facts make bad law. I don't exactly know the facts of the case that, came out with that holding, but you're going to have cases in just about any case that you litigate where you have to deal with a case that's not great for your side. Even if you are dead set right on the law and the facts, there's just a lot of law out there, and that's why it's an advocacy system where you have to deal with that case. Now, that particular case, it does seem like quite the outlier, and if it were ever to be overruled, remember, you can only overrule a case if there's a legal question before a court in order to do so. That's why you're going to have a lot of cases out there that seem to have holdings that don't seem to jive with the rest of the jurisprudence. And it's because the court can't just sua sponte, meaning on their own, be like, hey, remember that Smith case that we decided a few years ago? We thought about it some more. Not great. We're just going to right now pull that opinion and replace it with something else. You can't do that. You have to actually have a case before you raising that legal question and raising that particular precedent from before in order to overturn it if that's what the court then wants to do. And so that's why you tend to have these cases that you have to deal with that, it might be that this particular case gets appealed up or the state has to deal with it and the court has to deal with it too. But it'll be interesting to see how they deal with it and how they address it.
And so let's talk about, if you looked at the filing, the prosecution, keep calling the prosecution, they're really the state, I think, in this in this circumstance, but they put together a little chart of their interviews with the jurors. Now, there were 3 jurors that they did not have a full conversation with. One who was like, I don't want to talk about this. So, you subpoena me and ask me to go to trial or go to court. Okay, but I'm not going to talk about it. And then 2 of them who are represented by some attorney, I think. One of them is the one juror who signed the affidavit. I assume that attorney was provided by Poot and Jim. And then I think Egg Lady is also represented by that same person. But they talked to a good number of jurors, and they asked them if they heard remarks on evidence by Hill, if they saw one-on-one chats with Hill, and if they had other concerns. And so Juror 193 said, as to that first question about hearing remarks, which is the most important thing, I think, no, maybe generally pay attention, is what she said. Juror 254 watched Murdaugh's body language, and I think 254 is the one who signed the affidavit, but I could be wrong. 326, no graphic material warning. So basically at some point she said, hey, you're going to see some graphic material. 530, no. 544, no. Generally pay attention, look at body language, and be observant. Now this is interesting from 544 because you can see how what 544 is saying could have been interpreted the way the affidavits said. So it's possible that she told them, when you're looking at witnesses, make sure you pay attention, make sure, you look at their body language, be observant, right? Just sort of a general statement about what they should do when they observe witnesses. And that became conflated into specifically watch Murdaugh. Now, the thing that I think is interesting, I think that is inappropriate. I don't think she should have told them that. I don't think it was Clerk Hill's job to tell the jury to watch people's body language and all the other things. Now, that is not overly prejudicial to Murdaugh, so if you have to show prejudice, then I don't think that gets you there. If you don't, though, if we're on that one case where, and I believe it was a bailiff in that case, and the bailiff said something to the jury, I'm not sure what he said, but it was just on point. In that case, in that court, it was just very strict and basically said, look, remember the court says anything to the jury that is material to the case, got to have a new trial. That's a crazy precedent, by the way. It needs to be overturned. If it hasn't been, it needs to be. And maybe this can be the case that does it. But if that one applies, if you apply that, then I think this is a little bit more problematic. And I hope you can appreciate out there why that seems like kind of a ridiculous standard, if that's the standard. Like, are you really going to overturn a trial? I mean, you guys watched this trial. You know how much went into it. You know how long it took. Are you really going to overturn a trial when the defense can't actually show that whatever bad thing happened prejudiced them in any way, was unfair to their client, harmed their client's rights, undermined their constitutional right to a fair trial. You can't show that, but you get a trial anyway. I think even if you're not a lawyer, you can feel why that seems like not appropriate.
And really quick on this, as we're going kind of down the list, this is the chart in the state's response. It's interesting to note, again, this is just a summary, right? Even the attachments are police reports, which is appropriate when you interview someone, the police writes a report. So they're not affidavits that are attached. There's no testing of what they said, because note that juror, their first response was, did you hear any, the exact question was, did you hear remarks on evidence by Clerk Hill? And the initial response is no. But then when they elaborated, they said the other things. And one thing that I want to note that I thought was very effective by the state's response was they quoted their opening statement, the state's opening statement, where they made comments along the lines of like, don't be fooled by Murdaugh, or don't be fooled by body language, use your ears. The things that were alleged to be said by Becky Hill in the Murdaugh motion, I thought that was very effective, because it at least goes to show there needs to be kind of testing of what these people remember. It is very possible this was a long trial, a lot of people talking. And in fact, the jurors may even be conflating who court staff are, right? They see a lot of people before they even know who people are. They kind of get the judge has a robe on. They get there's counsel at different tables, but there's official people coming in and out of their room, such as the clerk of the court. Is it possible that they conflated something they heard in court, which they affiliate with, official trial matters, with an official person, the clerk of the court, coming into their room? And we don't know that. They simply put that out there as this is something we should explore, whether these people are remembering what they heard to be from Becky Hill. I agree. If Becky Hill said, hey, look at their body language, I think that even goes too far. We've talked about how we go so far as to not even make eye contact or say good morning to jurors, just on the off chance that good morning comes off as code or some sort of instruction to the jurors. We quite literally ignore jurors ourselves. So you can see how, if that's kind of the stance that people in the court, officers of the court, being the attorneys, take, you can see how someone who has authority over the jurors says, pay attention to their body language, is too far. It's making comment on anything. Why body language? Why body language over their words? I think that's important to note, that there's kind of multiple things going on here. And the state's point of pointing this all out is simply to say there's a lot more to the story.
And I don't recall them doing this, but the judge also has opening instructions. So the judge gives jury instructions both at the beginning of the trial and at the end of the trial. And at the beginning of the trial, they're pretty general. And they are things like, pay attention. You're the judge of the witnesses and their credibility and all this other stuff. So I don't think it's outside the realm of possibility that these jurors are conflating what they're hearing from different times. They're remembering different things. And this just goes back to something we talk about all the time. It's like eyewitness testimony. This was a long trial. The clerk, various court staff are with these jurors a lot. They probably talk about a lot of things. They try and avoid talking about the case, obviously. But I can imagine there being some conflation here. Now, I do think this is why, even though, look, I read a lot of filings in my office, pretty much all the controversial ones I get to read at some point. And the lawyers will often put something in there about how we don't need an evidentiary hearing because it's so clear. And I always send it back to them and say, you can leave that in there, but you're going to have an evidentiary hearing. So you might as well go ahead and get ready for it. And this, I think there will be an evidentiary hearing. I would be very surprised if there's not. And I think when that happens, the judge is going to have the opportunity to really talk to these jurors about these things. Somebody asked whether or not this could be done anonymously. I would think that you would do this in a closed courtroom. It won't be anonymous. There will be a court reporter, but I don't think it's necessarily, I don't know what the rules and the law is in South Carolina, but I wouldn't expect a televised hearing with the jurors on the stand answering questions. To me, that feels a little icky, but I think it's going to happen. I think the judge is going to do the questioning. And I think probably the way the procedure will go is both sides will have the opportunity to submit questions to the judge. The judge will put all these jurors on the stand. They'll be under oath. He'll go through the questions. When the questioning is done, then the parties will confer with the judge again for follow-up questions, and that's the way this is going to go. And then at some point, the judge is going to make a decision. I think bringing in a new judge is a mistake if you really want candor from the jurors. The jurors are used to him. Jurors love the judge. They love the judge. They see the judge as like their protector and their father figure and all this other stuff. So I think he will be able to get the truth out of these people. And I still think, as I've said before, that this is not going to result in a new trial. And I think this filing makes me feel even more comfortable in that. I think at the end of the day, and Becky Hill has an affidavit in here too. And there's a funny part of her affidavit where she basically says, there are so many things, so many lies in what the defense said. I can't even address them all, but I'm addressing the ones that I've been asked to address, right?
I thought that was effective, by the way. Everything. She doesn't address, I mean, look, she was attacked in the Murdaugh motion, but I thought it was a very effective affidavit to basically say, I did not say, and then a specific quote from the motion or the affidavits attached to the motion. There's obviously a lot more to do, but it was a good way without just saying like a lot of curse words, right?
And look, that was really important because when the defense filed this, they made a lot of very serious allegations, which, if true, are incredibly problematic. If she had taken the fifth, for instance, hired a lawyer and said, I'm not talking about this, that would have been really bad because that would have signaled there's a lot more truth to what's being said than we would like to think.
And before kind of all of those allegations were undisputed, the fact that they're disputed alone now because of her affidavit, very important. She doesn't quibble or equivocate on any of those comments. She says, I did not say, you know, multiple, I think it's 2 or 3 pages of her affidavit. But I think because there's now disputed allegations and facts, that also leads to needing an evidentiary hearing because you have one juror or at least an allegation that the juror heard this phrase and she directly rebutting it. And because you have the conflict of evidence, hence needing the evidentiary hearing. Now, just because I need, for completeness sake, to go through the rest of the jurors' interviews as summarized by the state. So we just talked about juror 544 who made the comment about hearing Ms. Hill say something about body language and being observant. Then you have juror 572 say, nope, didn't hear anything, just no. Juror 578 declined to discuss the case or deliberations, which they can. We've told you this. Even if law enforcement come and talk to you, you don't have to talk to them. Juror 589, nope, didn't hear her comment on any evidence. Juror 630, no interview at the time of this writing. So that's interesting because juror 578 declined. So that means they reached the person and the person was like, I don't want to talk about it. Whereas 630, the way it's written, no interview at the time of this writing, indicates to me that they couldn't reach the person. Probably means that juror didn't want to talk, but they probably never were able to find them at their house. If they knocked on the door, they left messages, the person never called them back. Then maybe they sent emails, never responded to the emails. So it didn't officially decline, but just, you know, hasn't been interviewed yet. Juror 729. Now this is really interesting. This juror said, no, I didn't hear her talk about the evidence. Just generally pay attention. Heard no body language comments. So that is in, you know, contradiction with what juror 544 heard. Again, all these people are trying to remember things that happened months ago at this point after a very long trial. But here you're beginning to see why I think we need to get to the bottom of this, because if she did say the body language comment, it's very serious. Here we have a juror specifically saying, I don't remember hearing any of that, and I was in the same room as all these other jurors. Then you have juror 826 say, nope, didn't hear her say anything about evidence. Juror 864, also no. One thing I want to note, this chart has like multiple columns. There's like a last column in the state's chart that says other concerns. So just totally open-ended, and obviously, they're probably tailoring this other concerns bucket to make the defense look bad. And I will note that on at least 2 of these jurors, they say something that, if you don't know what they're talking about, could seem like it's bad conduct. Juror 544, the same one who said that this person heard Ms. Hill say, look at body language, also said in the other concerns, warned by counsel Harpootlian of a subpoena if they did not talk. And then Also, juror 589 in the other concerns column said, spouse warned by Harpootlian of a subpoena if they did not talk. So, a lot of you may be thinking, whoa, it sounds like they were threatened to talk because Harpootlian is coming to their door and saying, I'm going to get a subpoena. And this is some sort of bad conduct, unethical conduct. Should we be reporting Harpootlian? No. So it depends how he says it, of course, right? He is technically correct that if there were a hearing, currently there is no hearing. If there were a hearing where there would be witnesses, the defense has the power of a subpoena, just like the state does. Now, generally, I haven't looked at South Carolina law, but generally, I don't think he can issue a subpoena to force them to talk to them without a court hearing. It would have to be to testify in the court of law. So he's not technically wrong. It may not be the whole truth, and a lay person may not know that they can't just be subpoenaed to talk and forced to talk about something.
Something else we learned, I don't know if we knew this or not, but the most concerning piece of evidence for the defense is the juror who deliberated, who gave an affidavit that said Becky Hill said all these things that were troubling. Well, that is juror 630. And juror 630 is apparently a tenant of juror 785. And 785, if I'm not mistaken, is Egg Lady. So this relation, it was such a bizarre thing. So 785 gets removed. She's obviously upset. She makes the most outlandish claims that the defense has. And then the one juror they have who actually wrote an affidavit is her tenant.
Which, by the way, you're right, we never knew this because remember, all the back and forth, including in the motions, was that the tenant and the tenant's boyfriend or girlfriend, I'm not sure which is the tenant and which is the boyfriend girlfriend, gets interviewed by the court, but we never made the connection, or it was never made for us, that the tenant that, you want to know, I was very confused by this all along. I was like, when you're in trial, how do you have time to deliver a refrigerator? But that's beside the point. When I'm in trial, literally, I don't have time to go to the, grocery store because the grocery store closes before I get home. I don't get dry cleaning done. I just start buying new clothes because you never get time to do laundry or dry cleaning. So I don't know when they had time to deliver a refrigerator. But this makes a lot more sense because they were on the same schedule, the tenant and the landlady. And so they were both not in trial at the same time. So maybe the refrigerator was delivered at midnight when they were both out of trial. Sorry, that's a side, total tangent. But we were told it was a tenant all along, right? The tenant we've been talking about who was interviewed by the judge is a juror. How is that allowed? And I say this because typically when we do voir dire, the judge and the parties will ask something general like, do you know anyone else in this panel? Right? In this veneer. And there's no rule against serving on a jury with people that you know. But this particular relationship is so close that it's a curious one to allow on the jury. Because when we ask that question, do you know anyone else in this panel? Oftentimes, because Brett and I do not live in a large town at all, someone's going to be like, yeah, that's my 8th grade teacher's, basketball coach's son. That happens all the time. And people will know 5 other people. They're like, oh, Joe over there, plays basketball with my husband. We hear those things all the time. That doesn't disqualify you. But there's always a follow-up question that says, is there some type of relationship with the person that you know in this room that causes some sort of hierarchy that would make you not able to deliberate independently? Because what you don't want is someone who is on a jury with their boss. Right? Even though we're both equals on this jury, I may not want to disagree with my boss because maybe I'm used to taking direction from my boss at work all day. It feels weird to to say that their viewpoint is stupid and I disagree with them. And so even though I know that I'm supposed to be my own person on the jury, you can see how that dynamic can lead to a situation where a subordinate person can't independently think for themselves. I would think a landlord-tenant thing is somewhat similar. A landlord controls whether you have a refrigerator or not. A tenant has to pay the bills on time or they can be evicted. There are lots of reasons that are not okay, but that people get evicted for, including maybe you just don't like somebody if they disagree with you on a jury.
Yeah, I mean, it's a hierarchical relationship. And so it does surprise me that they were on that jury together. Usually what we see is people who work at the same company. And they'll say, yeah, I've never, I know he works at the company, but I never talked to him. It's like, okay, well, we'll have to worry about that or whatever. But this is a little different. And I think, look, to sum all this up, now that we have the prosecution's response, I think it's pretty easy to see how this is going to go. Becky Hill has denied all the allegations. All the jurors have pretty much said, all the ones who've been interviewed, she didn't tell us anything about Murdaugh. You have this one juror who's done an affidavit saying bad things, but it turns out that juror is in a relationship with the juror who was removed. They are the removed juror's tenant. They're going to have an evidentiary hearing. I think it's going to be really interesting what comes out about that tenant and what she says on the stand. But even assume that she sticks to what she says in the affidavit, I think what the judge is going to say is, based on what I'm hearing here, there's not enough evidence to say this actually happened. The vast majority of the jurors say it didn't happen. The one juror who says it did is kind of conflicted here because of this relationship with the removed juror, the juror who was removed properly, and the judge is going to deny the motion for a new trial. I mean, that's what's going to happen. I do think there'll be an evidentiary hearing. As we've said, I don't know how you cannot have one given the conflicts in the facts. And that's what you do. Evidentiary hearings, you can't decide factual conflicts on the papers. If there's a material, in civil practice, you have something called summary judgment. And when you move for summary judgment, you basically say, look, they've sued me. We agree on all the material facts. It's really just a question of law. Like, take the facts everybody agrees on, apply the law, and either I win or they win. We don't need a jury because juries decide facts, right? That's kind of where we're at with this. If there were no disputed facts and it was just like, let's say everybody agreed that, Becky Hill said this exact sentence, and that's the troubling sentence, and everybody agrees, and Becky Hill admitted it in her affidavit, then it would just be up to the judge. The judge could just basically write something based on the law and say this statement is improper or not. But we don't have that. People disagree on the facts, and when that happens, as we've often said, affidavits are a great starting place, but you got to put people on the stand and question them and see their body language. Basically all the things that Becky Hill's accused of saying to the jurors, you have to do that and see who you believe, make some credibility assessments, and then write something up.
And one thing's clear, though. I agree with you. There's going to be an evidentiary hearing for all the reasons you listed. Becky Hill's going to have to testify. And that's going to be very interesting. She's obviously gotten a lot of heat, including from us, if those allegations were true. We kept saying if the allegations were true. And she obviously has published a book and she's been interviewed a lot. So she has already said a lot. That's going to be interesting because she is now going to have to take the stand if there's an evidentiary hearing. And whenever you've said a lot of other things, there's just a lot of material for the questioner to point to or to note inconsistencies with. So there's no way around it with her affidavit, and she is the center of the allegation. She's going to have to testify. And it's going to be very interesting what she has to say and how she comes through it.
Yeah, but I feel much better after this filing because when you read the defense filing, they made some really strong allegations and they backed it up. And you just didn't know. You just didn't know what was going to happen. You didn't know what Becky Hill was going to say, and you didn't know what the other jurors were going to say. Well, now we do. We know that Becky Hill and the rest of the jurors are going to deny this and probably deny it pretty strongly. And with that dispute is probably enough. The fact that there's a dispute is probably enough to defeat this motion. And the trial, at least on this point, will be upheld. And then basically what will happen is the judge will probably deny this. At that point, Murdaugh already has an appeal. He'll file a supplemental brief on his appeal, which will include this allegation. And then the appeals court will consider both his allegations about things that happened at trial that shouldn't have happened and the jury misconduct at the same time. And then make a decision and we can all move on with our lives. But unfortunately, for those of you who are so excited about Murdaugh Trial Part 2, I don't see that happening, certainly anytime soon, and probably never.
Absolutely. And I think you make another good point there. That's another really good reason why there has to be an evidentiary hearing. This is going to become another appeal issue. right? And so if for some reason there wasn't an evidentiary hearing, I could imagine the appellate court saying, look, there are disputed facts here. We need to send this back down to develop the record so we have a record by which to rule on your motion.
And it's sort of the opposite of what we got in Delphi, right? I mean, I think a lot of people, when this initially came out, their reaction was, this is frivolous, this is Poot and Jim are terrible, horrible people, and they lie about everything, and they should just deny it out of hand. And the problem is, if you do that, you end up with the same situation we have in Delphi, where there wasn't really a factual record developed, and now you're debating these things in the appeals court, and you really don't have everything you'd like to have for the court to be able to consider, and everything gets messed up, right? Like when you don't take it step by step and take the time to do it right, that's when you save time on the front end. You save 15 minutes on the front end and end up spending days on the back end.
I was going to say, or like years.
Years, yeah.
Yeah, no, I totally agree. I as soon as I read the state's filing, I texted Brett. I was like, that was a good response. Again, evidentiary hearings still should happen. There could have been something very bad that happened, but man, they did a good job in responding with Becky Hill's affidavit and also their investigation. They asked the right questions, and they showed how we should not take at face value what is being alleged by the defense. And then there's going to be an evidentiary hearing, and I am very interested to see how that goes, and we will certainly be covering that. But I can't believe we've already talked for 45 minutes, Brett. I literally thought we talked for 20 minutes, but you get me going about Murdaugh. Here we go. So before we sign off for the day, Brett, is there anything else you'd like to add about this filing?
The only thing I'll say is just to reiterate something I said at the beginning. These are good filings from both sides. If you want to see what some good lawyers do, take a look at both these filings. This is really how it's supposed to be done, and I think you'll get a lot out of them. So read these. You'll learn something.
Absolutely. Do we have questions today?
We can do a question.
Let's
sure.
do a question. Why not?
Let's do a question.
The night is young.
Let's see. We started getting questions, and those of you who are listening on Legal Briefs,
you get two
if you
shots.
leave a 5-star review, yeah, you get a second bite at the review.
I will
apple,
say
so
my favorite are the 3-star reviews with a question.
Right, exactly. It's like you don't get a question, you don't get to ask a question. Sorry, the rule is you have to leave a 5-star review, and usually they complain about that in the 3-star review and then ask the question anyway. Okay, so here we go. Okay, this person specifically asked on Legal Briefs, so I'm going to ask their question. That's the other thing. We got a long list of questions on the prosecutors. Well, we got a couple Legal Briefs.
This is like the fast pass at Disney or whatever.
Exactly. If you want to go straight to the front with your question, leave them on Legal Briefs. Okay, so this person has a question for you, Alice, and a question for me. So we're going to ask both of them. This is from 19notcal87, whatever that means. Alice, what are your top 3 non-Hallmark Christmas movies?
Oh, that's so good. I have more than 3. So I'm going to say the ones that I watch every year without fail. Love Actually, Elf. I watch more than 3 every year, as you can tell, but I'm trying to bump it up into the top 3. I love Home Alone. I just love it. It's like, I think I make a Home Alone analogy like at least once a week throughout the year.
Home Alone's a great movie. I remember seeing that when I was in elementary school. I had friends who were twins. So obviously their birthday was on the same day. And they had a birthday party, and part of it was we went to see Home Alone in the theater. So that's where I saw Home Alone for the first time. And it was... And it's so good. And it holds
so
up
good.
well, too.
And the first one, like the subsequent ones, I've seen them before, they're fine. But the first one is just so classic. And I think I've said this before, but I went to law school with someone who grew up in the actual Home Alone house. Like, she lived in it, and they...
Really?
Yeah, and they filmed it. Like, they paid them money to, like, get out to film it, which was, like, the coolest thing ever.
Wow. That's
I know,
awesome.
right? It was actually someone's house, and they filmed it in the house, which is even cooler because most of the times you build a set and like film it outside, but that was actually the house, the inside and outside.
Huh. There's a great commercial. I can't remember who it's from, like Amazon or Google. It's like If It Happened Today, Macaulay Culkin comes back, but this time he's got like, Hey Google or Alexa, and so he does everything basically by, voice command. It's pretty funny. You check it out. See if you can find it. I'm sure it's on YouTube somewhere. Okay. So my question.
Oh, your question. Okay, here we go.
No, you can go ahead. What were you going to say?
Oh, I was saying, don't get off so easy. What's your question?
Oh, well, my question is, other than the original, what is your second favorite in the Nightmare on Elm Street series? Please don't say 2 or 6. It would be hard not to judge you if you did. So the one thing I'll say about 2 actually has become sort of a fascinating psychological study because, this is a complete aside, because I think both the director and the main character were gay, but neither one of them were out at the time. And if you watch Nightmare on Elm Street 2 with that knowledge, it completely changes the way you watch the movie. And there's some great documentaries on it and like how this is all reflected in the movie. So I remember seeing the movie back when it came out and just thinking this is terrible. But now you watch it and it's like, this is fascinating. So watch it again. Watch it again with that knowledge, and I think you'll get something a little different out of it. But the best Nightmare on Elm Street, other than the original, and I think everyone agrees on this, is Nightmare on Elm Street Part 3, Dream Warriors, which is just incredible because it does the thing that I love in horror movies, where the victims sort of empower themselves and sort of fight back against the big bad. There's one of my favorite Friday the 13th movies, which gets panned all the time, is a similar concept. I can't remember if it's 5 or 6, but essentially one of the characters in that movie has psychic abilities and is able to fight back against Jason. I just love that. But anyways, Dream Warriors, fantastic, great movie, definitely second best. Has a lot of the original characters in it. Close is A New Nightmare. A New Nightmare, very meta, really good if you haven't seen it. Scary, one of like an actual scary movie. Wes Craven was in his sort of Scream era, so he was coming back around, and really good. And then obviously, I mean, I know you only asked for one, but Freddy vs. Jason's great too. It's a lot of fun. So, but I would say mine would be 3, A New Nightmare, and then Freddy vs. Jason in that order. But frankly, I love all the Nightmares on Elm Street, even the bad ones. Even the bad ones are good. So thanks for asking that so I can talk about like Halloween.
I was just telling people I have no idea what you're talking about.
We'll watch Nightmare on Elm Street Part 3 sometime, Alice, so you can experience it. Have you ever seen the original?
Who are you talking to? The fact that Nightmare is in the title means I never would have even thought to watch it.
I didn't know if like when you were like in high school, if you and your girlfriends ever had a sleepover and watched scary movies.
I am unchanged. I am the same person I've always been. I've always been scared of scary movies.
Blair's in the chat, so I should ask Blair.
You should ask Blair, and Blair will tell you that
Blair ever forced you to watch scary movies?
I am unforceable. I would walk out of the room when people watch like scary movies during sleepovers. I would be that weirdo sitting on the couch, like we didn't have phones back then, like reading a book.
Justine asked a good question. Have you ever seen Nightmare Before Christmas?
I have seen parts of it. I haven't seen the whole thing. I've seen parts of it. A cartoon is okay.
Okay, I see. Well, the Babadook has cartoons in it. There's like a cartoon section of the Babadook, so maybe you should watch that. Alice is like, I don't know what you're talking about. But
I literally have no idea what you're talking about. But those are good questions. Well, thank you, 19 No Cow.
Yes.
Not Cow.
That's all. We got one more legal brief question, but I'm going to save it because it's the only one we have. So if you're out there listening, you need to...
Go to Legal Briefs, leave a 5-star review.
Yeah, there's like literally, like looking at this, we're up to 182 questions, which is crazy that you guys have asked that many questions and left that many reviews. Only one of them that's left is from Legal Briefs. So you need to get on it. We got a lot of questions to ask. But
and we're not gonna like shift over Prosecutors Pod, questions over here. This is just the Fast Pass. You guys, you 106 of you, now you know this is the Fast Pass. Other people will hear this eventually, but by then, maybe there's 106 new questions.
There you go. Yeah, if you're listening right now, early, ad-free, and live because you're a patron.
There you go. So with that, if you haven't caught on, we answer questions for 5-star reviews. So go ahead. You can even edit your question. We don't care. We just like talking to you guys and getting to know you better as well. But thank you guys for tuning in, and really glad to be talking about something other than Delphi today. But I'm sure we'll be talking about both Murdaugh and Delphi again very soon. If you have questions about tonight's episode or want to ask additional questions that are to be covered on Legal Briefs, you can email us at prosecutorspod@gmail.com. Find us on X. I'm always going to call it Twitter. I'm sorry. Facebook, Instagram, lots of other places. I'm sure we are at Prosecutors Pod. With that said, until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutors Legal Briefs.
Mike is still upset that nobody watched Magic Mike with him. I'm sorry, Mike.
Wait, Mike, I love Magic Mike.
See, Alice would have watched it with you.
Wait, when did y'all watch it? And that's not a Christmas movie.
They watched it Thursday night. Well,
you
they
guys
watch movies all the time with
every
Alice
night?
now. Yeah. They were watching movies last night. If I hadn't
Y'all
been
are
sick, I would have watched
awesome.
with them.
You
But
guys,
I was sick. I was like,
look, I aspire to be you, but you know what I have been watching, which is like way too sad for a
my favorite
chat.
cricket team is my fantasy cricket team, which I think I'm in second place now. I was in first for a while, but my actual lack of knowledge about cricket eventually got me.
Work takes up most of your time. That's why you should use Stamps.com to save time with your mailing and shipping, and have flexibility to focus on more important things. Stamps.com can handle all your mailing and shipping needs, with rates up to 88% off USPS and UPS. Add flexibility to your day with Stamps.com. Go to Stamps.com/program to sign up for a special offer. No contract, cancel anytime. That's Stamps.com/program.